Welcome to Sexual Harassment, Legal Definitions. I'm Abby Marr, an Assistant Director of the Student Conduct Institute. Today we will be focusing on what constitutes unlawful sexual harassment in two related spheres, schools and the workplace. Specifically, you should walk away from today's training first, with an understanding of the history of legal prohibitions on sexual harassment in the workplace and in education, and of both employers' and schools' duties to prevent and remediate such conduct. Next, knowing what constitutes unlawful sexual harassment under federal law in both employment and education. What we won't be talking about today is what response an educational institution or employer must take when an instance of covered sexual harassment happens, as well as nuances in that required response depending on the conduct itself. But we encourage you to check out our other modules on Title IX and federal requirements to learn more about what those responses should look like.
Like other forms of sex discrimination, sexual harassment has been a pervasive phenomena for centuries. People, and predominantly women, have often faced the type of conduct we would call sexual harassment today in the workplace and in other areas of life. However, it is only relatively recently that our legal system has come to recognize sexual harassment as a prohibited form of sex discrimination entitled to remedy under the law. In fact, it wasn't until 1964, with the passage of the Civil Rights Act, that sex discrimination itself was made illegal on the federal level in many forms of employment. And it wasn't until 8 years after that, with the passage of the Education Amendments of 1972, that sex discrimination was made illegal in education on the federal level. And even after the passage of statutes that made discrimination on the basis of sex illegal in the workplace, in education, and elsewhere, it was an ongoing point of debate as to what conduct these laws actually prohibited. It was not at all commonly recognized by courts or others that sexual harassment was included originally. And as we'll discuss, once sexual harassment was recognized as unlawful sex discrimination, there have been several changes over the past few decades in what is considered sexual harassment that is unlawful in the workplace and in schools. Courts interpreting sex discrimination laws originally focused only on the narrow questions of did an action happen to an individual solely because of their sex? And would someone of another sex not have been so treated? In the mid to late 1970s, feminist lawyers, advocates, and theorists such as Catherine McKinnon and Lynn Farley fought to persuade courts to look more broadly. They argued that sexual harassment constituted a form of sex discrimination because it perpetrates sex inequality, it exacerbates unequal power dynamics, and it can have the effect of sending an individual a clear message that they do not belong in a given workplace or educational environment, or are not to be treated equally in those environments because of their sex. In making this argument, they were echoing arguments successfully made a few years earlier by civil rights advocates who argued that harassment on the basis of race is prohibited by parallel Title VII prohibitions on race discrimination in the workplace. And their arguments began to take hold. Federal courts in the late 1970s began to find sex discrimination in cases involving firing individuals for refusing their supervisors' advances and cases of hostile work environments. In 1980, the Federal Equal Employment Opportunity Commission agreed. It stated affirmatively that sexual harassment was a form of sex discrimination prohibited by Title VII. And in the same year, in a case called Alexander v. Yale, the Second Circuit Court of Appeals established that sexual harassment of female students could be considered sex discrimination under Title IX and was also illegal. In 1986, the Supreme Court finally spoke on the issue. In its landmark decision, Meridor Savings Bank v. Vinson, it confirmed that workplace sexual harassment was definitely employment discrimination if it was sufficiently severe or pervasive. In a case that involved a woman who alleged her supervisor committed a pattern of rape, sexual assault, and sexual harassment against her, creating a hostile work environment.
Before we dive too deep into the definitions, let's set the existing framework for the laws that govern sexual harassment in the workplace and education on the federal level. First, Title VII of the Civil Rights Act of 1964 makes it an unlawful employment practice for an employer to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of that individual's race, color, religion, national origin, or sex. Title VII only really applies to employers with 15 or more employees, and it does not cover certain categories of employees, like domestic workers. Title IX of the Education Amendments of 1972 makes it unlawful for any person in the United States to, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So this includes almost any institution of higher education, as well as all public K-12 schools and many private K-12 schools as well. Neither statute mentions the term sexual harassment. And while the two laws were passed in two different contexts, years apart, the case law interpreting what constitutes unlawful discriminatory conduct under each has tended to run together at times, with cases on Title VII heavily influencing cases on Title IX and less frequently vice versa. This is particularly true with respect to sexual harassment.
Okay, let's get into definitions now. We'll start with Title VII, since that is where the legal understanding of sexual harassment first took hold. As with all of the laws we're discussing today, what we know about Title VII's understanding of sexual harassment has been given to us over time through case law. And as I mentioned previously, Title VII and Title IX have a history of case law that tends to borrow conceptually from each other. So our understanding of sexual harassment made unlawful by each law is largely from this case law. Hence, you will hear many concepts repeated throughout our discussion today. The Equal Employment Opportunity Commission is a federal agency that is in charge of enforcing Title VII. They have summarized the common definition of unlawful sexual harassment in employment on their website. Unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature constitute sexual harassment when this conduct explicitly or implicitly affects an individual's employment, unreasonably interferes with an individual's work performance, or creates an intimidating, hostile, or offensive work environment. We often think of two types of sexual harassment: this hostile environment harassment and the quid pro quo harassment, when submission to or rejection of conduct of a sexual nature is used as the basis for employment decisions affecting an individual. Harassment doesn't need to occur between members of different sexes. In On-Call versus Sundowner Offshore Services in 1998, the Supreme Court confirmed that same-sex sexual harassment is also actionable under Title VII. And way back in Meritor Savings Bank v. Vincent, that first Supreme Court case confirming that sexual harassment was covered sex discrimination under Title VII in 1986, the court stated that for harassment to violate Title VII, it must be sufficiently severe or pervasive to alter the conditions of a victim's employment and create an abusive working environment. And this severe or pervasive standard is one that the court and the EEOC have focused on and wrestled with in Title VII ever since. This test is a totality of the circumstances test, meaning that we should look to the whole situation to determine severity and or pervasiveness. Some factors that may play into this analysis: was the conduct verbal, physical, both? Was it repeated frequently? Was it hostile and patently offensive? Who was the alleged harasser? Someone with power over the individual who was harassed, like a supervisor? Did others join in the harassment? Was the harassment targeted at multiple people? Although the EEOC's guidelines on sexual harassment explicitly addressed conduct that is sexual in nature, They note that other types of harassment, such as harassment on the basis of sex or gender or race, national origin, or religion for that matter, could also rise to the level of sufficiently patterned or pervasive that it would create a Title VII violation. So when are employers on the hook for taking action under Title VII? In a harassment situation, an employer is automatically liable for harassment by a supervisor that results in negative employment actions such as termination, failure to hire, or losing wages. If a supervisor is the harasser, the employer can avoid liability only if it can show it reasonably tried to prevent and promptly correct the behavior, and the employee unreasonably failed to take advantage of any preventive or corrective opportunities offered. For non-supervisors, employers are liable for their conduct if they knew or should have known about the harassment and failed to take prompt and appropriate corrective action. So what does this look like? What does this mean? It's a pretty fact-specific determination whether something is actionable sexual harassment or not, but here are two example cases. One where the court found such harassment and one where it did not. First, in Petrosino v. Bell Atlantic, a 2004 case, the plaintiff, one of the only female I&R technicians at Bell Atlantic's Edgewater Garage, alleged a variety of harassing conduct in her workplace, including incessant sexually offensive exchanges at the daily assignment meeting, omnipresent sexual graffiti, as well as a pattern of disparaging sexual comments made directly to her, and even one instance of being physically attacked by a coworker who groped and kissed her. While the lower court did not find that the conduct could be severe or pervasive, the Second Circuit Court of Appeals, which covers New York among other states, disagreed. They noted that, first, the depiction of women in the offensive jokes and graphics was uniformly sexually demeaning and communicated the message that women as a group were available for sexual or exploitation by men. Such workplace disparagement of women, repeated day after day over the course of several years without supervisory intervention, stands as a serious impediment to any woman's effort to deal professionally with her male colleagues. They further stated that, in this light, Petrosino's sexual assault by a drunken coworker within a few months of joining the department might well be viewed by a reasonable jury not simply as an isolated incident, but as a tangible extension of the pervasive, demeaning talk to Petrosino personally. The assault communicated to Petrosino that she was perceived, at least by one coworker, not as a professional colleague, but as one more woman available for sexual exploitation. Now contrast that case with Leibovitz versus New York City Transit Authority, a 2001 case in the same circuit. In that case, the plaintiff based her harassment claim on remarks made within NYCTA generally, but not to her in her vicinity, and much of what she knew about the conduct was second or third hand. While the jury in the case originally found that this could be considered severe or pervasive, the court rejected that verdict as a matter of law, stating that while evidence of harassment directed at other coworkers is relevant to an employee's own claim of hostile work environment discrimination, that, quote, the only way to characterize Leibovitz's environment as hostile or abusive was by expanding the concept of the environment to include venues in which she did not work.
Okay, so now let's turn to Title IX. While the definition of sexual harassment in Title IX was developed through case law, there was helpful guidance developed by the Department of Education Office for Civil Rights in 1997 and 2001 defining sexual harassment for the purposes of Title IX. These pieces of guidance synthesize much of the case law in one place, and while there has continued to be significant litigation, as well as quite a bit of back and forth inside OCR on addressing sexual harassment, these definitions set a common understanding of what would constitute sexual harassment that warranted a school's response up until the new Title IX regulations go into effect. In these, OCR tells us that for the purposes of Title IX, schools must take steps to prevent and remedy sexual harassment that includes unwelcome conduct of a sexual nature that is sufficiently severe, persistent, or pervasive that it interferes with or limits someone's ability to participate in or benefit from a school's program or activity. According to that guidance, when a school knows or should have known of possible sex-based harassment, it was required to take immediate and appropriate steps to investigate or otherwise determine what occurred. So this might sound familiar because of our discussion of Title VII. If the conduct is by an employee in the context of their job, the school was considered definitely responsible for acting. If an investigation revealed that the harassment created a hostile environment, the school was required to take prompt and effective steps reasonably calculated to eliminate the hostile environment, prevent its recurrence, and as appropriate remedy its effects. However, in two cases, Gebser v. Lago Vista Independent School District in 1998 and Davis v. Monroe County in 1999, the Supreme Court found that in the context of private lawsuits for monetary damages, schools are only on the hook if an official who has an authority to address the harassment has actual knowledge of the harassment and is deliberately indifferent in responding to that harassment. Further, the Supreme Court also defined sexual harassment more narrowly in Davis v. Monroe County Board of Education as unwelcome sexual conduct that is so severe, pervasive, and objectively offensive, it denies equal access to education. The Department of Education's 2020 Title IX regulations largely extend the Supreme Court's language in Davis to OCR enforcement as well. The OCR regulations define sexual harassment made unlawful by Title IX as conduct on the basis of sex that satisfies one or more of the following prongs. First, an employee conditioning educational benefits on participation in unwelcome sexual conduct, i.e. quid pro quo harassment. Second, unwelcome conduct by anyone that a reasonable person would determine is so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the educational institution's education program or activity. Or third, sexual assault as defined in the Clery Act, or dating violence, domestic violence, or stalking as defined in the Violence Against Women Act amendments to the Clery Act. The Department explains this definition as adopting the Supreme Court's formulation of actionable sexual harassment in Davis, but adapting it for administrative enforcement in furtherance of Title IX's broad non-discrimination mandate. They explain that they meet this intent by expanding the definition to other categories, including quid pro quo and Clery Act crimes that, unlike in the Davis formulation, do not require elements of severity, pervasiveness, or objective offensiveness in order for institutions to be subject to OCR administrative enforcement if they do not take action. The Department states that in the final rule, it has adopted the articulated Davis standard by defining actionable sexual harassment in the second prong as conduct that is so severe, pervasive, and objectively offensive. Because, unlike in the first quid pro quo and third Clery crime prongs, the second prong covers conduct that raises First Amendment concerns, i.e. purely verbal conduct, and these elements are necessary to ensure that speech and expressive conduct is not peremptorily chilled or restricted, yet may be punishable when the speech becomes serious enough to lose protected status under the First Amendment, i.e. where the speech is so severe, pervasive, and objectively offensive as to effectively deny equal access to education. This second prong, for conduct that does not fall into the first or third prongs, applies a more difficult standard to meet than had been required in previous adaptations, including the 2001 guidance. The 2020 rules also adopt the Davis versus Monroe language regarding when an institution is on the hook for responding to allegations of covered sexual harassment. So the rules state that schools violate Title IX if an official who has authority to address the harassment has actual knowledge of the harassment and the school is deliberately indifferent in responding. While there have been no court cases interpreting the Department of Education's specific formulation of sexual harassment in its regulations, there have been plenty of cases since the Supreme Court's Davis and Gebser cases that created the severe, pervasive, and objectively offensive definition of sexual harassment in suits for monetary damages. So we do have examples of what this might look like. One example can be seen in Hayut v. SUNY New Paltz from 2001. In that case, a student alleged hostile environment harassment directed at her by a professor in the fall of 1998. The professor began a practice of referring to her as Monica, as in Monica Lewinsky, in front of the class, saying things like, "How was your weekend with Bill?" and "Be quiet, Monica, I will give you a cigar later." These repeated references led other students in the class, predominantly male, to adopt the practice as well. The Second Circuit agreed that this met the standard for actionable sexual harassment, noting that in just about half the periods of instruction taught by Professor Young, which Hayut attended, Hayut was the target of Monica comments. These comments, moreover, were generally made at or near the beginning of the period, thereby setting the tone for the remainder of the class period. The court also noted that Professor Young continued the harassment by referring to Hayut in her absence as Monica, and that the Monica nickname, pulled from the headlines covering the contemporaneous Clinton-Lewinsky scandal, can be readily understood as having powerful sexual connotations and overtones. And in this regard, quote, that Young's remarks were potentially taking advantage of an offensive societal stereotype of the woman underling who uses her sexuality with a person in authority to further her career. We can contrast the Hayut case with Mosavi versus Mount San Antonio College, a Ninth Circuit case from 2020. This case involved a single hug that the recipient of the hug, a student, alleged was forced upon them by a classmate. The Ninth Circuit found that, quote, even if Brown had admitted that the non-sexual simple hug he described to Jones was given without Mosavi's consent, that isolated incident would not constitute the severe and pervasive harassment required to prevail under Title IX. So you might have noticed that Title VII and Title IX do not define sexual harassment the same way for the purposes of when an employer or education institution must act, nor do they agree on when an institution is on notice of sexual harassment and required to respond. Namely, under Title VII, as we touched on briefly, a covered employer must promptly and thoroughly investigate when it knows or should have known about sexual harassment and take reasonable steps to prevent and promptly correct it. And the harassment definition for Title VII includes conduct that is severe or pervasive. A clear way to think about this is that the universe of conduct covered under Title IX exists entirely within the larger universe of conduct covered under Title VII, with the exception, in theory, of cases of employee quid pro quo, harassment, and VAWA crimes that would not be considered severe or pervasive. And note that for educational institutions in circumstances where they are both an employer and educators, these laws may apply at the very same time, to the very same conduct. And a final note, that state law also complicates the matter. Most states have their own anti-discrimination laws that cover sexual harassment, particularly in the workplace. While many borrow from federal standards and definitions, they don't all. So don't forget that layer and keep an eye out for modules to specifically touch on this point. Thanks for joining me today as I walk through the important, nuanced, but sometimes dry and confusing legal language defining sexual harassment, as well as the differences under Title VII for employment and Title IX for education. To recap, while there are nuances here, there are some grounding principles for recognizing sexual harassment. Is the conduct unwelcome and either sexual in nature or on the basis of sex? Is it affecting someone's work or educational environment? Then it might be covered sexual harassment. And while the standards of how much or how severe conduct needs to be before a court will find it to be illegal sexual harassment is a bit unclear and looks different depending on the content and the law you are looking at a base level, employers and educational institutions are responsible for preventing and remedying sexual harassment that occurs within their communities. And here are a list of the cases and guidance that we mentioned today.